It is now my absolute honor to introduce Kristen Clarke, who is the head of the Civil Division at the U.S. Department of Justice, lawyer extraordinaire, creative and brilliant mind. Kristen, come on out.
Good morning. It is an honor and a privilege to be with all of you today. This week marks the 65th anniversary of the Civil Rights Division of the U.S. Department of Justice, which came about as a result of the Civil Rights Act of 1957. I'm particularly pleased to seize this moment to talk about the work that we're doing to address the pervasive discrimination faced by people with mental health disabilities across our country. Much of that work relates directly to your theme of the criminalization of mental illness. Other parts of our work concern related issues, including the segregation, isolation, unequal treatment of people with mental health disabilities, and more in schools, housing, employment, service systems, and in other areas. Those forms of discrimination often contribute, sadly, to criminal justice involvement as well. Addressing mental health issues through a disability rights lens has power and promise. Too often in our national discourse, mental health is viewed as separate and apart from other disabilities, and we limit our goals and truncate our vision for people with mental health disabilities. When we do that, increasingly we've recognized that people with disabilities should have full lives with equal opportunities and should be treated with respect and dignity. But when it comes to people with mental health disabilities, too often we focus only on access to treatment. Certainly access to treatment is important, but it matters what kind of treatment is offered, and most of all, it matters what opportunities we offer people with psychiatric disabilities to live full lives. That reflects a much broader and more ennobling vision than simply access to treatment. It also involves, for example, access to housing, jobs, equal educational opportunity, and other important aspects of life. Finally, it matters whether we hold our systems accountable to treat mental illness as a disability rather than a crime. All of these things help determine the kind of lives that people with mental health disabilities can live: a life of isolation and poverty, a life entangled with the criminal justice system, or a life of fulfillment integrated into society. They are about more than simply treatment. They are about recognizing the humanity, the dignity, and citizenship rights of all people, including people with disabilities. The Americans with Disabilities Act, one of our nation's most important federal civil rights laws, affords people with mental health disabilities the right to equal opportunity in our country. Attorney General Merrick Garland recently observed, as we mark the anniversary of the ADA, that the Justice Department will keep working tirelessly, marshaling all tools made available by this groundbreaking law to realize the ADA's promise of equal opportunity for all people with disabilities. The Civil Rights Division's mental health-related work enforces the rights granted by the ADA and other federal disability rights laws. A significant part of our work is enforcing the ADA's integration mandate for adults and kids with mental health disabilities. That is the right to have services administered in the most integrated setting appropriate. The integration mandate is a powerful tool to address not only the warehousing of people with disabilities in long-term care facilities such as nursing homes, but also the cycling of people with mental health disabilities in and out of emergency departments and psychiatric hospitals. as well as their needless incarceration and avoidable encounters with law enforcement. No child with mental health disabilities should be subject to needless stays in hospitals, residential treatment centers, and juvenile justice facilities. We have been enforcing the Integrate mandate to achieve these goals. In 2021, for example, we issued a letter of findings concluding that Alameda County, California was violating the integration mandate by failing to provide community services such as mobile crisis services, assertive community treatment, housing services, supported employment, and peer support sufficient to prevent repeated admissions of people with serious mental illness to the county's psychiatric emergency department, psychiatric hospital, and jail. The same gaps in community mental health services that lead to unnecessary hospitalization also lead to unnecessary incarceration. Indeed, more than 50% of the people who were committed to Alameda County's institutions while homeless were also incarcerated at some point in the county jail. In Alameda County, as in so many other places, Black people with serious mental illness faced a disproportionately higher risk of being needlessly hospitalized or incarcerated. In 2021, while Black people made up just 11% of the county's population, they accounted for 53% of people who the county identified as justice-involved and high utilizers of mental health services. Our investigation of Alameda County found that on any given day, hundreds of people with mental health disabilities were hospitalized at the county's psychiatric hospital or institutionalized for lengthy stays at one of the several large locked subacute facilities, that people stayed at the subacute facilities for 6 months to 2 years on average, and that of those in the county's psychiatric hospital, many were there for weeks or months and were funneled to other segregated facilities upon discharge. Many people were institutionalized repeatedly and sometimes incarcerated due to a lack of community services. In one instance, a 20-year-old man's parents were told upon his discharge from a brief stay in the county psychiatric hospital that they should call 911 and ask for the police if he needed further help. Days later, when the young man was still in crisis, his parents called 911 and told the police, who responded that he needed mental health treatment but was not a danger. Rather than being offered crisis services, the man was taken to the county jail, where he later died, apparently after being left chained to a cell door unattended and trying to strangle himself with chains. Our investigation also found unconstitutional conditions at the county jail resulting from their failure to provide adequate mental health services, treatment planning, and discharge planning, and their failure to properly treat suicidal inmates. Inmates with serious mental illness experience worsening mental health conditions, repeated cycling for acute care at the county psychiatric hospital, prolonged restrictive housing, and sometimes serious physical harm or death. From 2015 to 2019, at least 14 prisoners died by suicide in the jail. One of our top priorities is working right now to resolve the allegations concerning Alameda County's violations of the integration mandate, and we're optimistic. We're also participating in settlement discussions with private litigants in the resolution of litigation concerning the treatment of people with mental illness in the county jail, and we're continuing to assess conditions in the jail under the terms of that settlement agreement. During the last year, the Civil Rights Division has also been looking nationally at needless confinement of adults with mental health disabilities in institutions such as adult homes, nursing homes, psychiatric hospitals, and other facilities. We currently have investigations in South Carolina, Missouri, Kentucky, and Oklahoma, And we're continuing to enforce settlements involving confinement of people with mental health disabilities in adult homes in New York, in a state psychiatric hospital, in a state-operated nursing facility in New Hampshire, and in adult care homes in North Carolina, and in state psychiatric hospitals in Georgia. In Mississippi, we recently won a trial in a case challenging the state's over-reliance on state hospitals and its failure to provide sufficient community mental health services to prevent needless institutionalization. We're currently defending that victory on appeal. Our recent community integration work has also focused in significant part on children with mental health disabilities. Too many of our young people end up in juvenile settings or in out-of-home placements, often in different states, far from their families, disrupting their lives in ways that can never be repaired. In the last several months, we've issued findings concerning Nevada and Maine and found that these states were violating the ADA's integration mandate by failing to provide the intensive home and community-based services needed by children and youth with mental health disabilities, resulting in their being institutionalized in psychiatric hospitals, residential treatment centers, and in some cases, juvenile justice facilities, often out of state, hundreds of miles away from their families. Of the children it served in residential treatment centers between 2019 and 2021, Maine shipped 46% of them out of state. Nevada sent out of state 43% of the kids placed in residential treatment centers in March of 2021. Many of these kids have experienced numerous institutionalizations. One parent we interviewed in Nevada told us that her 14-year-old daughter had been institutionalized 47 times in residential treatment facilities in and out of state, in hospitals, and in juvenile detention centers. 47 times. How could that possibly be helping her get better? We encountered numerous similar stories of kids bouncing between hospitals, shelters, juvenile justice settings, and residential treatment. And often these kids have been segregated from their families for many months at a time due to the unavailability of the services that they need. We are committed to repairing these issues across our country. In 2019, we resolved a similar matter in West Virginia involving the needless institutionalization of kids with mental health disabilities. Like in Maine and Nevada, our findings in West Virginia revealed that large numbers of these kids were staying for lengthy periods in segregated residential treatment centers out of state, far from their families because of insufficient in-home and community-based services. And often kids in these facilities who acted out were sent to juvenile justice facilities. Our settlement agreement with West Virginia requires the state to expand and develop community-based services, including wraparound services, behavioral support, and family support services, as well as in-home therapy, children's mobile crisis services, therapeutic foster care, and assertive community treatment, so that children with mental health disabilities in residential treatment centers receive timely access to the community-based services that they're entitled to. I want to turn now to the law enforcement context. This is another significant area of our work where we are standing up to respond to behavioral health crises issues in this setting. And again, we're using the ADA as an important tool here. We currently have ongoing investigations of policing practices in Louisville, Minneapolis, and Phoenix, all of which include an ADA component that's looking at whether county dispatch systems could make reasonable modifications to their practices by sending a mobile crisis team or other response to calls involving people with mental illness, particularly where the situation doesn't call for a law enforcement response. we recently launched an investigation in Oklahoma City, focusing exclusively on the city's practice of sending law enforcement responders to nearly all emergency calls involving people experiencing behavioral health crises. Experience shows that the presence of police often escalates the behavioral crisis. Too commonly, people with mental illness, particularly those who are Black and brown, have been killed during encounters with the police. We all recall the tragedies surrounding Daniel Prude in Rochester, New York, Deborah Danner in Brooklyn, New York, Miles Hall in Walnut Creek, California. About 1/4 of all people killed by police are people experiencing mental health issues. Just as we send an ambulance or a medic to respond to other types of health crises, such as a heart attack or a diabetic emergency, we should send a mental health response to emergency calls where that's appropriate. In many parts of the country, call centers that dispatch emergency responses can make reasonable modifications to their usual practices to afford people with disabilities an equal opportunity to access services, including by sending a mobile crisis team in appropriate circumstances where a call involves a person with a mental health disabilities and there is no need for a law enforcement response. Where a police response is called for, dispatching a co-responder team that includes a police officer and a mental health specialist may be a reasonable modification. In some situations, dispatching an officer with appropriate crisis intervention training may be a reasonable modification. Law enforcement agencies can also make reasonable modifications to their usual practices by arranging for a mobile crisis team or other responder to come to the scene where a law enforcement response is just not necessary. To be sure, what modifications are reasonable in a particular place depends on a variety of factors, which may include geography, demographics, the existence of mobile crisis services and other resources. But the key point is that jurisdiction should not assume that the proper response to a mental health crisis is always to send law enforcement without more, but instead should assess reasonable modifications to their usual practices, modifications that are feasible and appropriate, that will afford equal opportunity to people with mental health disabilities. In addition to looking at whether dispatch centers and law enforcement responders can make reasonable modifications to dispatch mobile crisis teams where circumstances call for that, in two jurisdictions, Louisville and Oklahoma City, we're also examining whether the state is providing sufficient community-based services to avoid the needless institutionalization and incarceration of people with mental health disabilities. State service systems play an important role in providing services that people with serious mental illness need to succeed in the community, and that can help prevent law enforcement encounters in the first place, such as supported housing, assertive community treatment, peer support, intensive case management, and supported employment. When state mental health systems over-rely on institutionalization and local law enforcement responses rather than providing crisis and long-term care services that would prevent needless institutionalization and incarceration, those states may be running afoul of the ADA's integration mandate. We recently announced an investigation into the state of Oklahoma on just these grounds to determine whether the state over-relies on institutional settings, including psychiatric hospitals and nursing facilities, to serve adults with behavioral health disabilities. And in May of this year, we launched an investigation into the state of Kentucky to examine whether the state provides inadequate community mental health services in the Louisville metropolitan area, causing adults with serious mental illness to experience unnecessary, frequent, and repeated institutionalization and law enforcement encounters. These state investigations go hand in hand with investigations of the local emergency response system and the local law enforcement responders. It's important not only to ensure the coordination of crises responses where appropriate, but also to ensure that the community services needed to prevent crises and hospitalizations are actually available. We're also focused on ensuring that courts are appropriately interpreting and applying the law in this area. And to that end, we filed numerous friend of court briefs or statements of interest in a number of suits brought by private litigants. For example, we recently weighed in a case brought by the family of a young Black man with mental health disabilities who was killed by police after being shot 23 times in the parking lot of a McDonald's in Montgomery County, Maryland. After an employee called the emergency response system to report that the man was, quote, acting crazy by not paying for his food or moving, but was not dangerous or threatening, the emergency response system sent an armed officer and did not request dispatch of either the police department's crisis intervention team or the county's mobile crisis team. We filed a statement of interest that educated the court on the relevant issues, including the ADA's requirement that public entities make reasonable modifications to their ordinary policies and practices to avoid discrimination based on disability. Further, we're also working with our colleagues at the Justice Department's Office of Justice Programs and with the Department of Health and Human Services on a guidance directed by President Biden's recent executive order on advancing effective and accountable policing and criminal justice practices to enhance public trust and public safety. That executive order directed the Justice Department and HHS to issue guidance on best practices for responding to calls and interacting with people in behavioral or mental health crises or people with disabilities. The guidance is to include consideration of co-responder models that pair law enforcement with health or social work professionals, alternative responder models such as mobile crisis response teams for appropriate situations, community-based crisis centers, and the facilitation of post-crisis support services, including supported housing, asserted community treatment, and peer support services. Please stay tuned for that document. These issues are also manifesting themselves inside of our jails and our prisons, and we're currently enforcing and working to protect the rights of people in correctional settings, ensuring that they have the right to adequate treatment, including mental health care. For example, in December of last year, we found that Connecticut was violating the Constitution and other federal rights of children held at the Manson Youth Institution, a correctional facility for children under 22, almost all of whom have a mental health diagnosis, the vast majority of whom are Black or Latino. And we found that the kids at Manson were not receiving appropriate mental health assessments or treatments. They needed special education services that they weren't receiving, and they were subject to isolation practices that caused serious harm. One boy who had deteriorated after his brother was shot and killed had a mental health assessment that did not uncover this history or identify any trauma-related diagnosis, and identified him as simply having a conduct disorder and not in need of mental health services. Another boy who had been stabbed in the chest and had nightmares about the stabbing was also found not to need mental health services, and the impact of this trauma on his mental health was never explored. In April of this year, we found that Mississippi violated the constitutional rights of people incarcerated at the Mississippi State Penitentiary, including failure to meet their mental health needs by providing inadequate mental health assessments and treatment, deficient suicide prevention measures, and prolonged exposure to solitary confinement under grossly inadequate conditions. We're also working to address segregated and inadequate education for students with mental health disabilities, and looking at these issues and how they're playing out at our colleges and universities. We're continuing to litigate an ADA case challenging Georgia's use of a network of segregated schools and segregated classrooms for students with behavioral-related disabilities. These schools deprive students with disabilities of opportunities to learn alongside non-disabled peers and offers an inferior education. In some cases, students with disabilities were consigned to the same school buildings used to segregate Black children years ago. 2 months ago, we announced our findings that the state of Alabama violated the ADA by relegating hundreds of kids with mental health disabilities in its foster care system to segregated and inferior educational programs on the campuses of psychiatric residential treatment facilities. Kids in foster care who are placed in these facilities are often enrolled automatically without an appropriate educational assessment in segregated on-site schools. These educational placements sever children's ties to their homes, their teachers, social activities, and peers. Last year, I'm going to turn now to colleges and universities, we entered a settlement with Brown University in Rhode Island to resolve claims that Brown violated the ADA by refusing to allow dozens of students who took leaves of absence for mental health reasons to return to school, even though they met the requirements for returning to school, and even though their treatment providers reported that they were ready to resume their studies and participate in campus life. The settlement agreement provided that Brown would revise its policies and practices, provide ADA training to faculty and staff, and compensate the undergraduate students who were harmed. Colleges and universities' policies concerning how students with mental health disabilities are treated continue to be of great concern. Some colleges have policies that require students experiencing mental health crises to take leaves of absence without considering whether other options might be appropriate. Some require students who've taken such leaves to remain out of school for lengthy periods of time beyond when they're ready to return, and some bar students on such leaves from even setting foot on campus, including areas open to the public. We will continue to prioritize this work in the road ahead. Let me now turn to how these issues play out with respect to people with substance use disorders. This is another important area of our disability rights work, looking at discrimination faced by people with opioid use disorder and substance use disorder. Earlier this year, we issued a guidance explaining the ADA's protections for people with opioid use disorder. We've done a significant amount of enforcement in this area with settlement agreements resolving claims that bans on use of legally prescribed opioid treatment medication in a variety of settings violated the ADA. By way of example, we recently settled claims with the state of Indiana concerning their state nursing board's rehabilitation and monitoring program that required that nurses with substance use-related problems barred them. They had a policy that essentially barred them from using opioid treatment medication, and we found that this violated the ADA. One of the complainants in this matter felt that nursing was her calling in life, but she chose not to enroll in the program, which was required for restatement of her nursing license because she believed that staying on her opioid medication treatment was a matter of life and death for her. People with opioid use disorder should not have to choose between taking lawfully prescribed life-saving treatment and pursuing the career they want. We also settled with the state of Colorado, a homeless service provider in that state that had prohibited recipients of its housing and employment services from using these treatment medications. And right here in Pennsylvania, we're currently challenging restrictions imposed by some courts within the unified judicial system on the use of opioid treatment medication by people who are in court supervision programs. We're also working with the Massachusetts U.S. Attorney's Office to facilitate their resolutions with the state's Department of Corrections and a number of sheriff's offices, ensuring that people in jails and prisons have basic access to needed opioid treatment medication. I'd be remiss if I didn't talk about artificial intelligence, because it plays out in all of the contexts that I've just talked about. Earlier this year, the division issued an important guidance document concerning the ADA's application to hiring tools that use algorithms or artificial intelligence. These tools can sometimes discriminate by asking questions that screen out people based on disability, rather than their ability to do the job in question. Given the increasing use of algorithmic tools in many employers' hiring processes, this guidance has important implications for people with mental health disabilities who may be inappropriately screened out of jobs based on their disabilities through personality tests and other screening tools. You've heard me reference several times the particular importance of some discriminatory practices on people with mental health disabilities who are Black and brown, and I want to highlight that the Civil Rights Division is committed to looking at all of these issues that I've talked about today through an intersectional lens and exploring the ways in which they may disproportionately impact communities of color. The overlapping impacts of discriminatory practices based on disability and race have appeared in many different contexts, and we have to find ways to address them. I want to conclude by lifting up the legacy and saying the name of Lois Curtis, one of the plaintiffs in the Olmstead case, in which the United States Supreme Court decided that the unnecessary segregation and institutionalization of people with disabilities was a form of discrimination prohibited by the ADA. Ms. Curtis died sadly just 1 month ago, but her legacy lives large. Ms. Curtis, who had spent much of her life cycling between psychiatric hospitals and jails, often being picked up by law enforcement after her family called for help, was eventually confined in a state hospital for years after she was deemed ready for discharge. Her compelling advocacy helped secure not only her own discharge to the community with the services that she needed to succeed, but also paved the way for so many other people with disabilities to live, work, and thrive in their own homes and communities. Ms. Curtis eventually moved into her own apartment, worked as an artist, and exhibited her work in art galleries. She painted beautiful, bold, and colorful portraits, one of which she presented to President Obama in the Oval Office. She also became an advocate for the rights of people with disabilities following her success at the Supreme Court. And her legal battle was in some case about access to treatment, at least which kinds of treatment and how and where it was delivered, but it was really about something much more than that. In fact, it was about so much more than simply treatment, because the vision that Ms. Curtis fought for is captured by what she told a reporter who asked her what she wanted for all of the people with disabilities who transitioned from institutions to their communities. And she said, quote, "I hope they live long lives and have their own place. I hope they make money. I hope they learn every day. I hope they meet new people, celebrate their birthdays, write letters, clean up, go to friends' houses, and drink coffee. I hope they have a good breakfast every day, call people on the phone, feel safe," end quote. Her words powerfully capture what we're fighting for every day in the Civil Rights Division at the Justice Department. The vision we have for people with mental health disabilities is to have the same kind of lives as people without disabilities, with the services they need, but also the markers of human dignity and the ordinary things that we take for granted every day that are essential for a life well lived. Thank you so much.